obtained by the witness is hereby taken as evidence in chief of DW1 in this case before this court.
As court pleases.
Yes.
Now, in paragraph 9b of your statement on oath, you refer to.
Did you provide the list of?
Yes, my lord. Yes, my lord. Yes, my lord.
Is it filed before this?
Yes, my lord. Attached to our defense. Let's go, please. No, after. After the exit.
Okay. I've seen them.
Let's go, please.
Yes. You were saying that,
yeah, in paragraph 9b, you refer to an offer of appointment letter dated February 12th. Offer of appointment 9b. Refer to offer of appointment letter dated February 12th, 2020.
dated
2012. Dated February 12th, 2020.
Yes.
Also in paragraph 16.
Yes.
Refer to a payment slip dated April 2020.
Is it dated April 20th?
Of April 20, I'm sorry, my lord, of April 2020. Yes. Payment slip of April 2020.
Yes.
Then in paragraph 17, refer to GTB statement of account. Dated, that's print on the December 8th. Printed on December 8th, 2022.
Yes.
And you, in paragraph 29, refer to a certificate of compliance in support of the account statement.
In support of what?
The GTB statement of account.
Yes.
Then in paragraph 37 of the counter claim, refer to an engagement letter dated December 1.
Engagement or disengagement?
Engagement letter, yes. Engagement letter.
What is the date of it?
December 1, December 1st, 2022.
Yes.
These documents, I will confirm these are the documents you refer to.
Yes, I can confirm.
Okay.
Yes.
Now, some of these documents are photocopies. I need to recall where the original are.
Okay, so I lost those some of the originals while I was relocating from Lagos, where I was working originally, to Benin, where I work now. And every means to get them have proved abortive.
When you are relocated from Lagos to where?
To Benin.
Yes.
Hello, we only seek to tender these documents.
Yes, it's quite the document.
Okay, well, the offer of appointment dated February 12, 2020. It's a photocopy. The pay slip of April 2020.
That is what number is that one?
That is
Number 2?
yes, number 2. Then the account statement.
That's
Number 3. Yes, ma'am. And the letter of engagement is number 5.
Yes.
Hello, we only seek to tender this document. It's an evidence in this case. Yes.
Okay. You have objection with regard to
the payment already tendered the documents already. It's not as
which of the documents that you tendered earlier.
the
You said we have with regards to one of the documents.
that the defendants tender.
Which of the documents?
This is the pay slip.
The pay
Slip. The defendant's pay slip for April 2020.
for February
2020. Yeah, the intended by
on the ground that
given the standard the document and it is marked exhibit 3. Don't have for that.
regarding the rest of the objection.
We don't have.
Well, with respect to the remaining documents, we have no objection. Mr. Emmanuel?
Yeah, my lord, the document doesn't offend any of these documents.
The document is referring to?
Yes, my lord, does not offend the rules of the Honorable Court.
I don't get you. What I say?
My lord, the claimant counsel grounds for objection was that because they have tendered it from their own part, that the amount of surplusage. So to surplusage. So this is our own case. So I don't know why the claimant is trying to object to the documents. We only seek that this document be admitted.
Yes. So, you know, certainly reason you said he is contending that the document had already been tendered.
Yes, my lord.
And you ask a question that you don't know why he is now objecting to that.
Yes, my lord. My position is that the document does not offend the rules of the Honorable Court.
The document while being tendered.
Yes, my lord. It doesn't offend the rules of the Honorable Court.
Does not offend the rules of this court.
And we only pray this court to admit sin.
We hereby urge the court to discountenance the objection of the claimant counsel and proceed to admit the document.
Let's copy it.
You can hear his approach to your objection.
Yes, my lord.
Do you have anything to say?
I replied that he didn't say that. He talked about something similar. And a document that is tendered, which is on the same call, cannot be tendered by the defendant and claimant in the same marks. Once he has it, and whatever that's before the court is the same thing that the defendant wants to tender.
Not regarding the or is it your opinion that it should not be tendered again by the defendant?
Lord, I will do the necessary to seek and provide guiding principles to this effect.
That's what I said. Do you have any authority to guide me?
Before me, I don't have.
At the moment you don't have.
Yes.
Okay.
Because my little brother will probably use on what to active. He can also guide us.
Because he made reference to the code, which is very vague. do not make reference to any specific provisions of the rules, and therefore you now hanging on that one and say you will you don't have authority to provide one. Okay, let me clear this.
Yes, please.
Take this. This is my ruling. In the course, the defendant's counsel applied to tender in evidence the documents identified by the witness before this court. The claimant's counsel stated that they have no objection except to one of the documents sought to be tendered in evidence by the defense counsel, and that his reason for the objection is that the document is already in evidence, having been earlier tendered and admitted in evidence in these proceedings. However, claimant's counsel maintained that he does not object to the rest of the documents sought to be admitted. It is clear from the contention of the claimant's counsel that the document being objected to is the document titled Payslip of February 2020. The rules regarding the admissibility or otherwise of documents in evidence under our law are considered from three broad factors. These are: one, whether the document is pleaded; two, whether the document is relevant; and three, whether the document is inadmissible. See the case of Augu against Woye and others, 2015 LPLER 4676, Court of Appeal, and also the case of Oguleye against Aina and others, 2010 LPELR 4694, Court of Appeal. In both decisions above, I have not seen instance where the Court of Appeal held that if a document is earlier tendered in evidence by a party in a matter, such a document or similar one cannot be tendered in the same proceedings by either or one of the parties in the suit. What is important is whether the document could be said to have been passed the three broad tests or elements. In the present case, though the document is said to have been tendered in evidence and same admitted and marked as Exhibit C3 before this honorable court, I find no law that precludes the defendant from tendering a similar document as in the instant case. It is in this regard I overrule the objection raised by the claimant's counsel regarding the admissibility of the payslip of February 2020 sought by the defense counsel. Having said so, these documents are having been pleaded, they are relevant, and I find same admissible, are hereby admitted in evidence before this court in this suit and shall be marked as: one, offer of appointment, later dated the 12th day of February 2020, Exhibit D1, first defendant's payslips for April 2020, Exhibit D2, part of the first defendant's GTB statement of account of February 2020, Exhibit D3, terms of engagement between the defendant and the grantivor's law of office is Exhibit D4, and certificate of compliance with the provisions of the Evidence Act is Exhibit D5 respectively. Yes.
Okay, witness.
Yes, please.
Are you there, witness?
Yes, I'm here.
Okay. Now, what do you want the court to do for you in this case?
So I want the court to dismiss the claimant's claim and grant my own counterclaim.
As court, ma'am, that is all for the witness.
Any cross-examination? Be mindful of the time listed on the witness box over there. So that we can save time. Hopefully you can proceed with the cross-examination of the witness.
Witness, can you hear me?
Yes, I can. Yeah.
Okay. Witness, have you been to India before?
Yes, I have.
Okay. Who sponsored your trip?
So I've been to India on more than one occasion.
I can't tell you.
I have been to India on more than one occasion.
The question
You may have to be specific.
India.
So the first trip was sponsored by Dangote. The second,
thank you.
yes, the first trip.
Thank you.
Is that the claimant?
That's the claimant.
Yes.
So when you provided with a selection and training bond by the claimant.
Selection data.
Yes.
And what?
And training bond by the claimant.
Yes, I was.
I need to say yes.
Yes.
Yeah. Did you execute this training bond?
Yes.
Witness.
And I'm reporting it.
Yes.
Yes.
Yes. So witness, do you know one Adekunle A and Adelogun Michael
Adekunle
A Wambade and Adelogun Michael Olusegun.
Yes, I know them.
So my Lord.
Yes, I know that.
Yeah, said you know.
Yes.
Yeah. So who are they?
So Adekunle Bangbade is my father, and Adelodun Michael is a family friend.
Adekunle is my father. And
Adelodun is a friend of the family.
Adelogun.
Yes, Olusegun.
A family friend.
Said Adekunle is the father.
Yes.
Yeah, Adekunle, if I got it right, a family friend.
Yes.
Yeah. So witness, is there execute this bond as your guarantors?
Yes.
Okay.
Yes. Go ahead.
Witness, by your paragraph 7 of your witness statement.
Yes.
You said that you did not accept the terms and conditions wholeheartedly because the claimants forced you. True or false?
Come again.
Witness, by your paragraph 7 of your witness statement on oath, you said that you did not accept the terms and conditions wholeheartedly because the claimants forced you. Yes or no?
Yes.
Yes. So
Because the claimant
forced you.
what's your reaction?
So witness, what do you mean by that? Say yes. Say yes.
What do you mean?
So witness, what do you mean by that? Or who exactly forced you in the claimant organization?
Okay, thank you. So it was a case of not having an option, right? Because if I didn't sign it,
Please,
I wouldn't.
can
Can you hear me?
your lordship is recording.
Okay,
You
okay.
not having an option.
Yes, because if I didn't sign it, I wasn't going to get the offer or get the job.
If you don't sign it, you'll not be able to get one.
The job.
Yes.
So witness, are you trying to say that without the claimant's you cannot get a job anywhere aside the claimant's organization?
Now the claimant offer,
Yes.
you will
You
not
cannot get a job elsewhere aside the claimant's organization.
elsewhere
Yes.
without
Without claimant's of a offer.
yes. Witness, what's your reaction? What's your answer?
Say there's no option.
Can you hear him?
Can you hear the answer?
Yes, yes, I can hear you.
Okay, what's your reaction?
So my response was directly to the job. So it was the job in question they were talking about.
Is it what do you say?
My response is that it is that particular job that we were talking about, not any other job.
Yes.
So witness, indirectly, you are saying that it was the letter that forced you, the letter itself, the document letter that forced you.
What's your response?
I have no response.
Are you satisfied?
Hello?
Satisfied with him? He doesn't have a response.
So, witness, furthermore, you said you protested the 5-year employment bond. Yes or no?
You said you protested
The 5-year employment bond. Yes or no?
Yes, I felt it was excessive.
Yes or no?
Yes, I felt it was excessive.
So where, how, and when did you carry out this protest? Do you have proof to this claim?
I mean, since all this was contingent on getting the job or not, I had no choice but to sign anyway.
You have no choice that you sign the bond. Is that what you're saying?
Please say that again.
You said you have no choice than to sign the bond. Is that so? Is that what you are saying?
I signed the bond. Yes, if that's what I heard you say. Yes.
Is that so? Yes.
So, yes, are you aware that the training was in 2 stages, the classroom and on the job training? Yes or no?
No.
Sorry, come again. Yes.
No.
No. My Lord, we don't know how witness can see the selection letter.
You can show him on the screen if you call his attention to that.
So witness, can you see this selection letter? Which one? Yes, you in March 4th, 2016.
Yes, I can see a document, even though not
March
clearly, but yes, I
4th,
can see.
2016.
I can see a document,
March
yes, but not
Let
exactly
me
clear.
see.
But
Payments. So you can see GF.
yes, I can see you're trying to show me something. Yes, I can.
This can you read paragraph 2. Paragraph 2.
It's not clear, so it's
Look
not
at
clear,
it.
so I may struggle to read it.
Paragraph 2.
Honestly, it's not clear.
Yes. Or do you want me to read it out for you?
Yeah, maybe. Yeah, you can go ahead.
We don't have
time. Do you want me to read it out for you?
Yes.
All right.
All right.
Hello.
Hello.
Okay.
So the selection letter, which is dated March 4th, 2016, addressed to Mr. Bangwali Adedapo, 11 8 State, Airport, Alakia, Ibadan, Oyo State. Now let me read paragraph 2. It says, you will undergo classroom training in design and digital engineering. Further, you will also undergo on-the-job training with engineers India, India, where you will train on the job in your area of discipline. The next question.
So what is it?
Go forward to the next question. So by your paragraph 10, you deny that the claimants did not cover your training, cost fee, health care, and never provided a stipend to you.
That the claimant
Does not cover your training, cost fees, health care, and never provided a stipend to you. So readers,
Yes, I can hear you.
by your by exhibit C straight the claimant, which is also marked as exhibit B2 of the defendant. This is the basic. Include the cost. And also exhibit C3 also group that Dangote Oil Refinery training paid to stipend executive trainees. Your name is number 2 on the third column. Number 2, faculty and data for Yelwa saving. So will you be maintaining your stance? Having said that, they did not cover your training and cost and health when you have also said the affirmative that they sponsor your trip in India. Yes,
Yes, witness. Have you understood?
I'm not exactly clear on what he's asking.
I said you denied by your paragraph 10 that the claimant did not cover any of your cost fee or training. You even said the claimant, you put the claimant in the strictest group of the alleged. Now, having put forward the secret and then having answered in the affirmative that Dangote sponsored your trip to India, you should be maintaining terms that they don't expend more than they don't cover etiquette and dress. Yes or no?
Maybe if you give me a moment, I'd like to check that document myself and see exactly what you're talking about.
Say yes or no answer. I said that you went to India on their sponsorship, but you denied that they did not cover even your etiquette. So it's a simple answer. It's a yes or no. Go and verify anything. You are delaying the proceedings. Yes or no.
Anyway, so I have we didn't see any evidence to the claimant's claim of spending any money. There's no proof. There's no yes, there's no proof of expenses actually.
So are you telling us that to sponsor this? What you're saying?
There's no proof of the expenses that were made. We didn't know how much we spent.
Oh,
there was no proof of the expenses that were made.
Move forward to the next question. So witness, are you aware that it was because you executed that bond that the claimant extended the amount of you?
Please say that again.
Are you aware that it was because you executed the bond that alone made the claimant expend that amount on you, on your death state and your training and hospital?
Yes.
Yes.
So move forward to the next one. Further to your claim that you were forced, forced.
Yes.
Witness, by your garant of force.
Okay.
Yes or no? By your garant of force.
It wasn't signed wholeheartedly. It was contingent on me getting the job or not.
Or it was the next question. That's not really clear. What are you saying, witness? Yes or no?
It was contingent on me getting the job or not. So they had no choice.
What are you saying?
They had no choice, basically.
Have no choice. As not it. Another proceedings. Witness. By paragraph 9F, you stated that it's clearly agreed. It was clearly agreed that the claimant can leave the employment of Dangote Petroleum Refinery and Petrochemicals FCE.
That what?
That Dangote Petroleum Refinery and Petrochemical FZE.
Yes.
That's either party that the claimant can leave the employment of Dangote Petroleum Refinery, and that's what you do. Or witness, it's you that you can leave the employment of Dangote Petroleum Refinery and Petrochemicals FCE by either giving Dangote Petroleum Refinery and Petrochemicals FZE.
Answer. The point of asking this question, provided.
So whether he's still in the employment any of these companies.
Not very clear, even for me.
So meanwhile, business are you in the employment of any of companies you mentioned? Are you still in the employment? Yes or no?
No.
Okay. So as specified there, if by any chance, if any notice, either 2 weeks or the most salary in lieu of notice, if you then
Yes, I resigned with immediate effect.
you have a resignation letter.
Via mail, it was during the lockdown, COVID.
You have a resignation letter. Yes or no?
Yes, I resigned via mail. Yes.
And it's not before the form. So take that into last question. So witness, are you aware that you are in breach of the agreement for a 5 years period in the employment of the claimants by abandonment?
No.
So I can't hear you.
No.
Yes.
That will come for witness.
Very well. Any examination?
No, my lord.
Yes. What next?
We shall be applying for a date for final address, my lord. And we only seek to only apply that the witness be discharged, my lord.
We also, as we said, the second week of finance, they don't have a witness. We also
Did you hear it? Application?
say
That is all, my lord. The witness is for the entire defendant.
So, witness, you can send Can you hear the court?
My lord, yes, I can.
Very well. Now, defendant case is through.
As God pleases.
Um, Having closed the defendant's
Defendant's
case,
case,
parties can proceed to filing
filing
their
the
final written address. In this manner, the defendant's
defendant
final written address shall be filed and served within
in
21 days,
21 days,
which will expire on the 30th day of December 2025. While the claimant has to file his own final written address within 21 days upon being served by the defendant's counsel, which will expire on or on the 20th day of January. The defendant's counsel any reply within 7 days, which shall expire, which will expire on the 27th day of January 2026. It is upon the conclusion of all filing or expiration of the days and dates above given that this court is to give date by issuing on council, on both council, a hearing notice for the adoption of the respective final written addresses.
That's stop please. Vamos Grisner.
Very well.
not right. Or